Thank you very much, Dr. Tanti, and thank you for all of you for coming in here today. It is a little bit more about me. I've been practicing motivational accident injury law for about 20 years, and I don't practice anything else. So this is, and I run a boutique law firm over on 101st Avenue and about 78th Street, not far from Dr. Tanti's office. I want to try today to try and integrate what they've said with my experience and tell you what it's like to go through the legal system having to run a motor vehicle accident injury claim. So if somebody comes in my office or I interview them over the phone, I'll get them into my office, and the first thing I look for are signs, right? Signs that are often hidden, because people are often focused on their main injury, the one that hurts the most, okay? And they'll be talking about their back, they'll be talking about their hip, they'll be talking about their consciousness, and then they'll start doing this, right? Also, so tell me about your jaw. Well, I've had this weird jaw sensation ever since the accident. I don't know what it is. Well, can you put some pressure here and open your mouth wide? What is that? What happens? Oh, it hurts. Well, how about we get you a steak or an apple or something like that? Oh, I can't do that. Well, do you have any idea what that is? No, don't have any idea what that is. Well, that's temporal mandibular joint dysfunction. Well, how do I get that? Well, motor vehicle accident, whether it's a side impact or a front impact, your jaw, who does one of these or one of these, and that affects your jaw joints. And that's a very common injury in a motor vehicle accident. If somebody comes in and they are wearing dark glasses or they are looking down, I will ask them, does this light bother you? And they will say, yeah, the light bothers me, even looking at a computer and stuff. You want me to turn this light down? Yeah, I can turn that down. That tells me post-concussion syndrome or concussion. So the first thing we look at is what the patients or what the clients do not tell you, because that's the function of a really good injury lawyer. Find out what the people are not telling you. They're going to tell you a number of things, but it's like being a doctor, an investigator. You have to find out things they're really not saying. Okay? Now, absent liability for the accident and those sorts of things, let's say I sign up my client. And I explain my fee agreement, and they want to go and have me represent them. I say, okay, I represent them. And what I have to do in the legal process is very well connected with how their treatment goes. Have they reached maximum medical improvement from their PTSD, from their concussion, from their back injury, from their orthopedic injuries, whatever it is. In a lawsuit, in a motor vehicle accident claim, you have up to 2 years to file a statement of claim. And that is an exception for that. If you're a minor, you have up to 2 years after you turn 18. So what happens in that time? I say on my website, I deal with the insurer at the insurer stage. And if I can't deal with the insurer at the insurer stage, I have to go to stage 2. That is the litigation stage. The litigation stage, a lot of people are not really, they don't really understand it, and they may not be comfortable with it. But I say, generally, if you have an accident that you can resolve, or an injury that can be resolved within that 1 year, maybe it's a PMJ and a cap soft tissue injury or something very small, you can resolve it within a year. Unless, of course, the insurer says, we're only going to pay you X, and I think it's Y. And we're off to litigation, right? So we have to look at, it's the common question, how long is my case going to take? And I have represented people with deceased people with fatal accident claims. I have represented people who are quadriplegia, paraplegia, traumatic brain injury, mild traumatic brain injury, concussion, and chronic pain. Chronic pain is a common one. And they're all different. They're all different. And the thing you got to kind of watch for with especially a chronic pain injury is this something that's going to be resolved with treatment, right? Because, as I think Dr. Canty had mentioned, some of these things will resolve early, but every once in a while, you get one that doesn't matter what you do, whether you go to the chiro, the physio, the treatment center, what it is, it's still there. After 2 years, after 3 years, you can't work, you're constantly medicated, and what are you going to do with these people? So, we, as personal injury lawyers, work closely with the medical profession, because without the medical profession, we're not going to be able to prove our case in order to go to trial. And I say to my clients, what's the number one way to settle your case without going to trial is to show them you're ready to go to trial. Okay? Now, what does that mean from a legal standpoint? We operate by a thick book called the Alberta Rules of Court. And that thick book tells you what the things that you have to do in litigation. There's family rules in there, and there's whatever, but in any event, rules like you have to file a statement of claim in a specific time. Rules like you have to file an affidavit in a specific time. Rules for examination, for discovery, and questioning, explain what that is. All those sorts of rules. And they take time. So, I need to be able to say, how is it that I'm going to be able to prove my claim to the insurer or the defense lawyer on the other side so that we don't have to go to trial? Because I've seen cases where people don't use experts like this, and they want to say, yeah, okay, well, let's set up trial. And it's been 10 years since the motor vehicle accident. And they come to me and they say, should this be happening? And I say, well, have you hired any experts to prove the case? No, he hasn't sent me anywhere. Mm-hmm. I think you're going to get steamrolled, right? So, if I know somebody has a TMJ injury, I gather the clinical records from their previous dentist. Then I send them to my TMJ specialist, who will then likely diagnose TMJ dysfunction. They'll go for treatment for the TMJ. It's usually paid for by Section B. Always a difficult problem when you have only Section B paying for your benefits. If you've got a private benefit plan, great. They always say, great, use that private benefit plan. Because some people say, well, I've done the 21 treatments and I can't pay for anything else. I'm like, ugh, bit of a problem. So, I know my client has a orthopedic injury or even chronic pain. What am I going to do? Am I just going to rely on their clinical records, hand that to the other side and ask for money? No, it doesn't work that way. I mean, that would be very insulting to the insurance company who does very, very good work, very good investigative work, and hires excellent defense lawyers to be able to defend these claims. Okay, so they're on the other side of this. I'm on this side of this, right? And I'll tell you, I'm going to say this again, it makes very much sense. If the insurance company treated you fairly, I would not have a job. And that's the honest truth, right? And I do well what I do. So, the insurance company is not going to say, well, I'm going to send you to this expert to make sure you've got... No, because then they get expert evidence to... And they're going to pay more. Pay more in the long run, right? They're going to say, oh, okay, what does the doctor say? Who says this? Who says that? And it's not to their advantage to be able to get extra evidence. So basically, you end up sitting there, following your doctor's advice. Doctor maybe... And doctors don't like to give out MRIs very quickly because they want you to kind of go through a course of physiotherapy, go through a course of chiropractic. And I've seen that, where they go through a course of physiotherapy and they think it's a musculoskeletal problem, but it just doesn't go away and it ends up being spinal. Send them off to an orthopedic specialist. They send them for an MRI and they say, look, bulged disc, herniated disc, angular tear, nerve root impingement. Great, now I've got those. Okay. And I can say, here's what's wrong with my guy. Now, the next thing to remember is what happens if there's various hits of damages in a lawsuit. It depends on what you're claiming. Most people know that general damages is for pain and suffering. So, for pain and suffering, you get X amount of dollars. But let's say you have loss of housekeeping, because you're unable to take care of your house for a period of time. There's a case called Russell and Turcotte that says, stemming from a case called Fogle and Dean in the Supreme Court of Canada, that even if others pitch in to help do the work, it doesn't matter if you actually expend money on doing that work. It's still either non-pecuniary or pecuniary. Pecuniary damages are things like lost wages. So there's a claim for past loss of income. There could be a claim for loss of future income. So we look at how we're going to be able to prove these damages. There may be a claim for loss of future income or incapacity. Okay? I may have somebody who is 23 years old, gets into an accident, ongoing chronic pain, or maybe quadriplegia, or severe brain injury, or whatever it might be. I'm going to need a vocational report. That vocational report is going to rely on the occupational therapist that I retain. That occupational therapist is going to rely on the orthopedic specialist I retain. So it's like building a house. You don't throw all the tradespeople in the lot and say, go. Right? You get the people in there to dig the hole. You get the people in there to hook up the utilities. You get the people to do the framing or the basements and framing and drywall and all that kind of stuff. And that's the way it works. Same thing with a personal injury case. So that orthopedic specialist provides a report, and the OT looks at it. And the OT does an FCE, functional capacity evaluation, and actual testing with a person to determine their functional capabilities and restrictions. That is built upon the orthopedic report. Now, I'm going to get my, vocational expert is going to say, look, the OT said this person only has the physical capability of doing X when before they were doing Y. And that translates into loss of income. But I'm not a loss of income expert, so let's get off the vocational. The vocational person then looks at all kinds of statistics and studies, examines you, gets your, it does various questionnaires, interviews you, and comes out with it can come out and say, look, because this lady could no longer work doing this, she could only lift a certain amount of capacity, right? The National Occupational Code says that is a light level, or medium level, or maybe heavy level. I don't know what it is, okay? For whatever example. And they will say, her previous job required her to do this. Now she's only capable of doing this. That gets taken off to an economic specialist. So this is how we deal with experts. Experts are very important. Medical experts especially to us, because at the end of the day, I'm going to have to prove my case at trial. And I'll tell you what, at the end of the day, they might run away and say, yeah, okay, you got me, and we know what your case is worth, give me an offer, let's see if we can settle. So that's kind of how we work with medical experts. One medical expert has to give us an opinion, and I've had concussion, NTBI, neuropsychologists say, I've reviewed all the clinical records, your client has done the testing, your client comes in here and we've done an interview. Based on everything that I've seen here, here's the report, and maybe she doesn't have an NTBI. Maybe she does have an NTBI. We don't know it until I get that report, right? There may be a history of just psychological dysfunction, psychological disorder. And they might say, we think it's kind of related to that. We don't think it's something related to a traumatic brain injury or mild traumatic brain injury. Usually I find, though, that if there is a a history of treatment. Somebody's had vertigo, for example, dizziness, balance problems. I look and I say, okay, something's going on here. You need to see a specialist for that, okay, to get that treated. So listening to your client is one of the most important things you can do. Relying on your experts is another one of the most important things that you can do. Yes?
Do you find that the expert opinions that you're retaining for your clients, so they're writing a report and saying this is the problem based on their findings, are those usually pretty coinciding with the expert opinion from the insurance perspective as well, or are they usually pretty similar, or are they sometimes like not even close?
In the litigation?
Yeah. So
who are we kidding? There are paid advocates. I am not lying. I'm so surprised when I first entered this profession, and you will get one, or I can name the bad orthopods that will always give you a crappy report, right? And I can name them because they're always retained by insurance companies, never retained by plaintiffs, right? And they're going to say, nah, you don't have this, no, you don't have that, no, your injury should heal in 6 weeks, nah, you know, it's like, great. Now I've got to hire an expert to combat that, right? And I know that, for example, and I'm going to throw some names out there. Well, there's one in Calgary that's traditionally, she's a neuropsychiatrist. Traditionally big advocates, okay? But there's also a gentleman in Calgary, a neuropsychiatrist, who loves rebutting her reports because he went to school and kind of knows it, right? And he'll come back with a rebuttal that says, no, she's wrong here, why? No, she interpreted this incorrectly, why? Because this study, blah, blah, and he'll just destroy her, right? So yes, it happens in litigation all the time. We want to know who you're retaining, if it's a Dr. Grady, if it's a Dr. Trump. And some of us say, you know what? They're going to be easily undermined, cross-examined, and stand. But do we necessarily want to go to trial? If we have to, we've got to prepare ourselves to. So that's the way where we can settle the case without having to go to trial.
Couldn't the ones that you send them to, couldn't they be the same way?
They can be interpreted by the other side as the same way. But I can tell you that all my experts, some of them are also retained by the defense. Some of them are not. And their reports make sense. You can draw from their facts, you can draw from their studies, you can draw from their conclusions and their opinions, and there's little to undermine there, right? Where I know a doctor, another one, DePercio, for example. DePercio will give you 60 pages, right, of a very, very extensive report. He's largely retained by the defense. Goes on, talks about all the studies, talks about this, does a complete medical review, gives his opinion at the end, and his conclusion, and you read, no, this can't follow, right? Because as you're reading it, you're saying, oh, this is going to be a good report. And then at the end, it's like, why would you say that? It doesn't follow really what you're saying. It follows the facts, right? So, yes, in fairness, are the people we retain, we're going to say plaintiff friendly? We're certainly not going to retain people that are defense friendly. So we know who they are and we try to avoid them. Defense is the same thing. They know we hire and they try to avoid them, right? Some experts, like Dr. Keegan, for example, hired by both sides, testified in more trials and he's retired now than I'll ever probably run. Everybody respects him, right? Both sides.
Well, then you should both use them.
They do.
Yeah.
Yeah, and they do. Dr. Keegan has been, like I say, he's testified for plaintiffs and defense. He's well respected by both sides, and he's probably testified in court.
That's what everybody should use it.
Well, you put it this way: if there was an expert like that, that exists for every occupation, it would be a pretty fair world.
Yeah.
But when we have doctors that know they're being hired by insurance companies, they're going to lean their opinion over to the insurance company, right? Lean their opinion over to the insurance company. That does happen in the litigation.
That includes WCB.
Don't get me started.
We don't talk about that.
Don't get me started. WCB, it's like, here, go to the Millard Center, okay, you're done, now go back to work. Pretty much. So anyway, when I talk about gathering these experts to prove my case, I do it because before I can get into trial, I have to go to a mediation or at least try and resolve it with the other side. It's part of the rules of court. Now, I put together a brief, and the defendants put together a brief. We send that to the mediator. The mediator, if you don't know, is an independent person who's trained in resolving disputes and helps the parties try and resolve the claim. Everything said in mediation is without prejudice, and you can say anything you want. Nobody can be called as a witness at trial. Everything in that room stays in that room, unlike a questioning or discovery where it's a court reporter there and people take, and they take a transcript of it. So that's one of the last steps before we go to trial. And along the way, the civil process goes like this. We file a statement of claim. Unless, of course, we can resolve it without having to file a statement of claim. Then we file a statement of claim within the 2 years. Okay? If somebody is resolving after 1 or 1.5, I don't wait 2 years and I get it done, file, go. Because civil litigation is slow. So then the defendants have, then the plaintiff has to take that statement of claim and serve it on the defendant personally. So we hire a process server. The process server goes out and finds the guy. Sometimes his name's on the collision report form. Sometimes it's a hit and run driver. Sometimes we don't know, but sometimes a demographic search will help us locate them. Other times we have to go to court to get an order for subservice or substitutional service by posting it to the door or publication or even sometimes on Facebook. That will happen. After that happens, then we provide that to the insurer who then says, okay, now I've got an affidavit of service that says my guy's been served, and so they hire a defense counsel. Defense counsel has to provide a defense to my claim within 20 days. We always give them professional courtesy if a little longer, and that's fine. The defense will always say, it's the plaintiff's fault. The plaintiff did this. My insured's not fault for anything. Or your client didn't mitigate, or your client, all the injuries were pre-existing, all that kind of stuff. And it just throws it right back at the clinic, at the plaintiff. What do you mean? This is a rear end motor vehicle accident, right? Are you kidding? That person's at fault for that? You think they're going to admit liability? No. They won't admit liability. So, after that, the process is for us, the plaintiffs, within 90 days to provide an affidavit of records. An affidavit of records is documents that are relevant and material to the claim, that things like the clinical records and collision report form and that kind of stuff, that the defense gets to examine them. They then have 60 days to provide their affidavit of records. Then we schedule an examination for discovery. What's an examination for discovery? It's now called a question. Every province in Canada calls it an examination for discovery. Why they changed it, I have no idea. But they get to ask your client about their injuries, where they went for treatment, how long have they resolved, have they not resolved, all the heads of damages, past loss of housekeeping, future loss of housekeeping, income earning capacity, all that stuff. And so that will take most part, a greater part of the day. So that now commonly occurs through Zoom, whereas before it was in person in the lawyer's office. So after this, we have to provide undertakings. What's an undertaking? An undertaking is a promise by me to get information that is relevant and material that's out there, but I just don't have right now. For example, they're going to say, when was the last time you saw Dr. Tanti about your back problem? And they'll say, well, I saw Dr. Tanti 2 weeks ago. And they'll say, well, my clinical records only go up to 6 months ago, so I'm going to ask you to undertake to provide the updated clinical records of Dr. Tanti. And they'll say, undertake to request. Okay? So that's an example of those undertakings. It may be income tax records. It may be, any of that stuff. Once I get those undertakings, now I take all those medical undertakings off to my orthopedic specialist. Here I talk about the experts again. Because that expert, if I just send my client to an orthopedic specialist, then it doesn't have the background information about the clinical records. The defense sends those off to their orthopedic specialist, and their report will beat mine every time. Right? So after the questioning, you get the medicals, send them to your ortho. And I do that because often the ortho will confirm or rule out various causes. And I also want to know if my clients fake it, because that does happen sometimes, right? When you have clients that think their injury is worth more, right? Or here's the medical evidence. Here's what I have the burden of proof in this trial. So my orthopedic specialist can issue an MRI report like that. So sends the client for the MRI, gets the report, and says, I think there might be some microvascular tears in the shoulder or whatever. It looks like a slap tear, superior leg on the anterior posterior. There's a special way of determining if exactly it is, and that's by gadolinium injection. Now I've got to send my client for gadolinium injection. And boom, I find out that they've got a slap tear or some other tear in the fibers, which not really identified before. Like some people look, my shoulder seems fine, except when I raise my arms above my shoulders, that really hurts. That kind of gives you an idea of what that is, right? So he confirms and rules out other causes. Then he recommends that I send my client off to an OT for a functional capacity evaluation. Based on a functional capacity evaluation, the FCE will say, okay, I would recommend a vocational if that's necessary. I don't get vocational for everybody. Right? It just doesn't, I don't just send people to experts to build up a case to try and get money. It's really what the experts say, and it's based on fact. Because if my chiropractor says, you know what, I think there's a certain problem here that can be identified in a different way that a chiropractor can't do. My client goes there, and boom, there it is. Now I've got another injury. So that's how lawyers work with various experts to build their clients' cases. And when I say build their clients' cases, it's to get them the fair compensation. Right? Don't be fooled about the rhetoric from the insurers that say injury lawyers are making all your insurance premiums more expensive. I'm not going to get into tort reform, I'm not going to get into auto accident insurance reform, but they've been at it for 20 years. And they're still making money hand over fist. So this is a case of, and by the way, on that argument, my fees go out of the client's settlement, not the insurance company. So that's a fallacy. I think that's really the main things that I want to say about how my job and works with the rules of court, it works with the procedure, and works with physicians and other experts to be able to prove a client's case, to be able to say, okay, let's get this person's case resolved instead of having to go to trial. Now, when I've got a case that's multi-million-dollar case, there might be going to trial, right? So it's a liability issue. Maybe it's only $1 million in the policy and have to get an SCF 44 involved. The SCF 4 is a rider on your own policy that pays for your damages and treatment if the insured's limits are above, are not above $1 million. So all these things that come into play, but as far as the experts go, I need to be able to look, examine, and say from the outset, okay, my client's sitting here, she's talking to me. What am I seeing? You're saying about this. Oh, yeah. The lights are behind here? Yes. Okay, PCS. What about dizziness? What about balance problems? What about this? What about that? Yeah, I've got all that stuff. Okay, so I know the GP could diagnose PCS, but only a neuropsych can diagnose mild brain injury. So I always say, mention all of your symptoms to your doctors. If you don't mention all your symptoms to your doctors, I can't get you full compensation for all of them. Okay? And, the more important thing is be honest with your physicians, be honest with your lawyer, and always listen to your client. Sometimes I find it difficult. I have clients, I read their charts and clinical records and stuff, and I see things like suicide ideation and those types of things. And it really bothers me. I swear, I probably talk one person per year out of committing suicide because of their pain, their suffering, whatever they're going through. And as an injury lawyer, that kind of hurts me because I see this all the time, right? And I have to listen to my clients, and I have to make sure that I'm paying attention to them. Because for God forbid, if I'm not paying attention to my clients, they're going to say, why didn't I go talk to James H. Brown? Right? Why didn't I go talk to whoever? So, I'll tell you a funny story. And sometimes people think I'm a counselor. I'm not a counselor, I'm a lawyer. Okay? And so they'll come in and they'll want to interview or talk about their case. And I had a lady who was 25 years on WCB, only for psychological injury. She worked in a place that treated difficult young adults and stuff like that. In any event, one came into her office with a gun and held her hostage. And at the first moment she had, she bolted out of her office and went straight across the street, put herself in her car and locked the doors and shut. Right? Her car became her safe place. Her car was in her safe. So you think she's going to be very easily getting back into her car and driving anymore? No. But, she worked through WCB and she goes talking to counselors and psychiatrists and whatever. She's still on WCB. Now she comes in and see me, right? And she kind of expects the same out of me. So I listened for about 45 minutes. And good lawyers know how to interview. We know how to gather facts. We know how to investigate. We know how to cross-examine. We know how to do all that kind of stuff. But after the 45 minutes, I said, you know what? That's something that's really important. Can I ask you? And she goes, I don't think you're listening to me. So that kind of thing does happen. Doesn't happen very often, but listen to your clients, and that's how we work with experts. That's a bit of a legal system that goes along into prosecuting the personal injury case. Usually ends up being resolved before mediation. Mediation is mandatory. If not, then you go to trial. And trials are long to get into, depending on how many witnesses you have to call. A couple of weeks, usually 10 days more. If you got their doctors, you've got my doctors, you've got maybe the husband or wife who wasn't injured but can testify as to the amount of housekeeping or how the personality or of the plaintiff has changed, right? So it's not just kind of collateral witnesses are great because they're kind of, here's the doctor saying, this has really affected this plaintiff's life, she can't do this and this, and here's why, and here's this guy. Get the mom in there, get the dad in there, get the whoever in there that wasn't in the accident, gets to see her every day, right? Doing this, or I can't do the dishes, can you help me? That's the kind of thing you want, right? So, I think my time is up today. I think that's about all I want to say, except for a couple of things. Thank you all for coming today. We expected a larger crowd. I brought a whole bunch of gift bags. So, there's a bunch of swag in there, things like pins, keychains, golf towel or a cycling towel or whatever, and of course the bags. Take two and whatever. I was hoping we would have a bigger crowd. I understand about. So before you go, and of course, questions, sir.
One thing you didn't mention,
Yes.
which is important, is fees.
33% of anything.
Fees.
Yes. 33% of anything I collect.
Fees.
Say again?
It's 33% of anything I collect for you. Speaking about fees, any lawyer that does lots of this stuff, any lawyer who's experts, any lawyer who's just, you can get lawyers from, I can say a few, they're from Ontario, and they come out here and try and run personal injury cases, or lawyers that are just beginning out and they want to charge 25% to get the case or whatever. Any lawyer that's worth his salt and does lots of this stuff will charge at least 33%, and some will charge graduated fees. For example, they'll say 33% if I file a statement of claim. Then they'll say 35% if I go to examinations for discovery or question. Then they'll say 37% if I have to go to mediation. Then they'll say 40% if I have to go to trial. Now, my fees are 33%. And why is that good? For one thing, the other lawyers justify themselves as saying, well, you know, I'm doing more work on your case, so that means I should deserve more money, right? And people go, well, yeah, I guess. And what I say is, if I'm doing more work on your case, it's because I'm getting you more money. More money for you means what?
More money for you.
Or you?
So why should I charge you more money to get more money, right? But anywhere aside from that, the top lawyer is 33% usually. But mine's a flat, not a graduated fee. Yes.
What percentage of cases do you usually settle outside of court?
98,
98. Wow.
97.
You said never admit fault, or somewhere I read that, I can't
Well, that's
remember.
right in your policy, don't admit fault.
Well,
that's
I can't
correct.
even understand that small print, so I don't bother, I know I have insurance. But that little fender bender, well, no fender bend, but anyway, that boom on 101st Avenue, I got out and I went up to her car and I said, I'm so sorry. When, and you hit me, and her husband's like, yeah, we'll just drive around the corner and we'll exchange our information. And then I went to the south side, that's where I live, cop shop, and I said, I was in this collision, I caused it, I was at fault, and I was told, oh, you shouldn't say that. And I said, well, clearly I was, I hit her in the rear end. How am I not going to be at fault? So in a situation, you know, and I never heard back from her.
Okay.
And then when I got the letter, within that 2 years, I phoned my insurance company because I was like, oh my God, I can't remember and the fellow that I talked to said, don't worry about it, put it right out of your mind, that's what you've got insurance for. So I don't know what they did, I don't know what they settled at,
Mm-hmm.
I don't know if we had the same insurance company, I don't know anything.
They probably resolved it before the stage of examination for discovery.
So
where you're really
what
necessary.
did I do wrong after admitting fault, like,
Well,
and reporting it?
Really.
two things. Yeah, nothing really, but there is a provision in your policy where you're not supposed to admit fault because it prejudices the insurer's right to defend you. Okay? Do they look at that very seriously? No. I'll tell you, if I was in an accident today, I'd say, sorry, dude, I fucked up. Right? It's my fault. And
You would do that? You would say that?
yeah, I
If
was.
you hit them in the back end, like
sure.
I did. I mean, it's
I would
how
say
is it
that.
going to be their fault?
Because some people, they get into accidents and smash into somebody, and they're clearly, you know, roll around, fall on the ground. First thing they get on the phone, they stand across the curb, go on the grass, whatever. They're not even talking or getting the information from the defendant, right? The license, registration, that kind of stuff. They're calling the company of the vehicle, they're calling their wife, they're calling their husband, they're calling whatever. What should I do? What should I do? What should I do?
Well, sometimes those people are in shock.
Yeah.
Like they've sometimes they are offline and their thinking brain isn't on and their protective brain is on. Where's my comfort? I'm calling my wife right now.
That's true.